Hello and welcome to this week's Tree Law TV, and in response to a request today we are discussing some case law. I've chosen the case of Leakey versus the National Trust to discuss today because it really does underpin some of the fundamentals in the law of nuisance and negligence that we deal with in cases relating to trees. So the story behind Leakey versus the National Trust is that Leakey is the claimant, and Leakey and another homeowner owned properties at the base of a mound of land. That mound of land was owned by the National Trust. There were some precarious falls of earth from the mound of land which landed close to the claimant's property, and they were concerned that there would be a failure of the mound which would cause some serious damage. It seems that by the late 1960s, the National Trust were well aware of the fact that there was a possible risk of a fall of earth from their mound of land and a risk of damage to the claimant's properties. So the claimant started a legal claim against the National Trust, a claim in nuisance and a claim for an injunction to carry out some works to the mound to stop that from causing damage to the claimant's property. And we've spoken quite a bit about the hot summer of 76 recently. Well, as a result of the hot summer in 76, there was a catastrophic failure of this mound, and earth and tree roots cascaded downhill and caused damage to the claimant's property. So the claimants brought a claim for damages and an injunction, as I said, against the National Trust. So what was the decision in that case? Well, the decision was ultimately one of the Court of Appeal, because the judge initially gave the decision and then the National Trust didn't like it, because obviously went against them, and appealed to the Court of Appeal. So the Court of Appeal held that the National Trust, they were liable, and the National Trust by the late 1960s, so this is probably some 8 years before the collapse of land and the damage happened, they were well aware of the fact that there was a risk of collapse to that mound and there was a risk of damage to the properties downhill. And as the landowners, they owed a duty of care to the two claimants to make sure that nothing would happen to the mounds that then could cause damage to the claimant's property. This is where the expression of leaky reasonableness comes from. It comes from this decision. So this is where the court said that the National Trust were duty bound to act reasonably. They obviously knew that there was a risk of damage caused by a collapse from their mound of land, and they failed to do anything. And that reasonableness test is when we bring in that balancing act, and when we look at what do the National Trust know, what work would they have had to do to stabilise the mound, how much would that have cost them, did they have enough money, versus what was the likely value of the damage caused if that failure had happened. And employing that balancing act, it was found that the National Trust knew well before the collapse actually happened, and they had the resources available to actually stop it from happening and stop any risk of damage. And actually, in terms of how much that work done to abate that nuisance, so stop it from happening, would have cost versus how much the damage cost, it was found to be reasonable in that case to expect the National Trust to have done some work. So what does that mean for us now? So although I'm largely specialised in tree cases, that leaky reasonableness, although that comes from a case that doesn't necessarily involve trees, I think there were some tree stumps mentioned, that reasonableness element and that balancing act still does apply. So if a tree owner, I'm thinking more along the lines of a commercial tree owner or a public sector tree owner, is on notice of a tree being a potential cause of future damage, then there is that reasonableness balancing act that should be carried out. What steps are reasonable for the tree owner to carry out to stop damage happening in the future? What's the cost of those versus what is the likely cost of the damage to the claimant's property if it happens? So really back to the reasonableness question and the balancing act. So that's a little whistle-stop tour through the story of Leakey versus the National Trust.